Hello, everyone. Welcome to Edison School of Law. Today, I'll be looking at human rights and land law in the UK. How human rights and land law intertwine in the UK. Overview: human rights and land law intersect where the exercise of property rights affects a person's home, private life, or family life. Since the Human Rights Act 1998, courts must interpret and apply land law in a way compatible with the European Convention on Human Rights (ECHR). This has had particular impact on possession proceedings, evictions, and disputes involving public authority landlords. Article 8 ECHR, right to respect for home, meaning Article 8 ECHR guarantees the right to respect for private life, family life, home, correspondence. A home does not depend on legal title. Factual occupation may suffice. Components: existence of a home, interference by a public authority, lawful justification, and proportionality of the interference. The locus classicus case is Manchester City Council and Pinnock 2010 UKSC 45, in which was held that courts must consider Article 8 in possession proceedings brought by public authorities. Eviction must be appropriate. Status: this is a leading authority and still good law. Purpose: the purpose is to prevent arbitrary or disproportionate interference with a person's home by the state. When and how does it arise? Article 8 arises when a public authority seeks possession or eviction affecting a person's home. Proportionality requires a fair balance between the individual's Article 8 rights and the public authority's legitimate objectives. Its components are legitimate aim, rational connection, necessity, and fair balance. See the case of Hounslow LBC and Powell 2011 UKSC 8, in which the court held that court may consider proportionality, but challenges will succeed only in exceptional cases. Status: this is still a good law. The purpose is to ensure eviction or interference is not excessive or unjustified. When and how it arises: it is raised as a defense in possession proceedings, including or involving public bodies. Public authority landlords. Who are public authority landlords? These are local authorities, housing associations in certain contexts, government bodies. They are bound by Section 6 of the Human Rights Act 1998. Duties: must act compatibly with conventional rights, must justify possession actions as proportionate. See the case of London Borough of Lambeth and K. Leeds City Council and Price 2006. This confirmed that Article 8 does not normally defeat a lawful claim for possession but may be relevant procedurally. Further development: Manchester City Council and Pinnock and also LBC and Powell refined the approach by allowing proportionality review. Limits of Article 8 in land law. Article 8 does not create proprietary rights. It cannot override clear statutory schemes. It is rarely successful against private landlords. Private landlords. Article 8 generally does not apply directly to purely private disputes. See the case of McDonald and McDonald 2016 UKSC 28, in which it was held that Article 8 cannot be directly relied upon in private possession proceedings. The relationship with land registration, human rights conservation do not convert personal occupation into proprietary interest or overriding interest under LRA 2002. They operate as procedural safeguards, not property rights. One sentence summary: human rights influence land law primarily through Article 8 ECHR, requiring courts to assess the proportionality of evictions by public authority landlords while preserving the distinction between personal rights and proprietary interests. Note: human rights have humanized land law without dismantling its structure. Proprietary certainty remains central, but eviction by the state must now pass a proportionality test grounded in dignity and justice. If you find this video useful, please comment so that we can share your own experiences in the next. To meet again, this is Edesiri Enoro of Edesiri School of Law. Thank you.